Thank you, everyone, for coming today. Before I introduce our speaker, I would like to thank the Roten Center for supporting this talk, Ed Knox, and the International Studies Program, Ian Barrow, for also supporting this talk. We are also grateful to the Department of History, Department of Religion, Brainerd Commons for their co-sponsorship of this event, and a special gratitude to Martha Baldwin and Charlotte Tate, who are amazing in helping us organize this talk today. This is the first of 3 talks that are associated with our International Studies seminar this semester. I see most of our students are sitting up front, as they were commanded to do, titled Islam and Human Rights, which I'm co-teaching this semester with Jeff Flynn. And it is my great pleasure to welcome the first of our speakers, Professor Nathan Brown, to Middlebury College. Nathan Brown is Professor of Political Science and International Affairs at George Washington University in D.C., where he currently serves as the Director of the Middle East Studies Program and where he has previously served as the Associate Dean of the Elliott School for International Affairs. Nathan Brown is an extremely accomplished scholar. He has authored several important monographs, including Palestinian Politics After the Oslo Accords, subtitle and another monograph, Constitutions in a Non-Constitutional World, Arab Basic Laws and Prospects for Accountable Government, and The Rule of Law in the Arab World, Courts in Egypt and the Arab States of the Gulf. Moreover, he has published dozens of scholarly articles and book chapters on issues such as constitutionalism in the Muslim world, on the current Iraqi, Iranian, and Afghani constitutional experience, Sharia and human rights, and constitutionalism, authoritarianism, and imperialism in Iraq. Over the past 2 years, he has taken a leave from his academic position at George Washington University to assume a position of senior associate at the Carnegie Endowment for International Peace. He has written numerous articles and policy papers in this capacity. The most widely read, if I can say, and anticipated by the public was his analysis of the final draft of the Iraqi Constitution. His professional activities also reflect his international renown and influence. In 2006, he served as an observer in the Palestinian legislative elections. In 2005, he was a member of the International Advisory Committee on drafting the Iraqi Constitution. And in the past, he has also served as a consultant for the United Nations Development Program on governance in the Arab world. As you can see, beyond the academy, the impact of Nathan Brown's work has been felt widely within the international policy community, and his work has been extremely vital to the field of Middle East politics and law. Today, he will talk to us about Islam, human rights, and constitutionalism. Please join me in welcoming Nathan Brown to Middlebury College.
Thank you very much, Phoebe, for an excessively generous introduction, or at least I thought it was excessively generous till you got to the end and you talked about influence on the world, which I think I have very little, but if influence is accompanied by responsibility for the current state of affairs, I want to completely disavow any impact on anything that has happened anywhere. Thank you very much for inviting me and for having me here. It's a convention in the Anglo-American tradition to begin a scholarly or academic presentation with first a joke and then with a set of kind of clarifying remarks. And I'm not going to do either. No joke, I'm sorry, and no attempt to sort of clarify the basic topic. Instead, I'm going to make my topic more confusing. And as my talk goes on, it will get even worse. The topic that I'm addressing, Islam, human rights, and constitutionalism, is sort of based, I think, what the task I think that I would logically set for myself would be to take these various elements and assess their, or just look at the ways that they work together. Islam on the one hand and human rights and constitutionalism on the other. And I might add, because simply the way that these terms are used, not simply human rights, constitutionalism, but also democracy. So that my talk would talk perhaps on a theoretical or a practical level about Islam on the one hand, human rights, constitutionalism, and democracy on the other. And in a sense, I'm going to do some of that. But what I want to do to begin with is to make the matter more complicated by observing that the second half of that, if Islam is on the one side and human rights, democracy, and constitutionalism are on the other, the second half of that balance is much more complicated than we often tend to assume. In current political discourse, we often conflate human rights, constitutionalism, and democracy, and there are perhaps some good intellectual and historical reasons to do so, but it's actually a fairly recent conflation. I mean, historically, critics of democracy saw it as the enemy of human rights or of individual rights. Constitutionalism was often seen as sanctifying the words of dead drafters over the will of current majorities. Constitutions were sometimes seen as expressions of the people's will and designs for basic structures of governments. Human rights protections were originally not necessarily a central focus of constitutional documents. They were added to the American Constitution after the document was drafted. And if you take a look at the first three constitutions that were written for sovereign entities, the American, the French, and the Polish, all three were about empowering government rather than, as much as they were about telling governments where they could not go. Now, I don't want to sort out how these things were related historically or why they came to merge in many people's minds. Those are very interesting questions, or the questions that I'm interested in, but I'm not sure I can give coherent answers, and I'm not sure I'd even be the best person in the room at trying to sort these out. But what I do want to say is the point that I simply want to begin with is that these are, as I say, the second half is a lot more complicated when you look at it, and when you throw Islam into the mix, it gets more complicated still. So that's what I'm going to be trying to do today. What happens when you throw Islam into the mix? Now, there's an easy answer to the question. And the easy answer, I think, is both theoretically and empirically misleading. And the easy answer, which you do hear, it goes something like this. An Islamic political order is one that is ultimately based on the sovereignty of God. And a democratic order is one that is based on the will of the people, the sovereignty of the people, human rights, perhaps sovereignty of the individual, and so on. And that these two things can't mix. And I think the beginning of that, there's some sense in that, yes, they do sort of ground political authority in different sources. But the idea that you can't mix them is, to me, very, very strange, because you can mix all sorts of things that seem to be sometimes in tension. Again, just a provocative statement about a political system that I don't know very well, except for the fact that I live here. The American political tradition certainly mixes sovereignty of the people, of the majority and the individual, in ways that we often forget or elide very easily between. So you can combine all sorts of things. The question is, to me, is not whether they can be combined in theory, but how they're combined, and what happens when you try to combine them in practice. That's where the really interesting questions and problems arise. So today what I'm going to do is first very quickly review this issue of whether you can build a constitutional democracy on an Islamic foundation in theory. I'm going to answer that question in a quick and superficial way, but I can go back in detail if anybody's interested. Then I want to go to the ground and look specifically and empirically, how is it that Islam actually appears in constitutional texts? And I'll look at the constitutional tradition that I know the best, which is the Egyptian. Third thing I will do is then look to see what happens in practice when you try to, with the language and institutions that the Egyptians have adopted that are similar to some others, especially in the Arab world. And I'm going to focus specifically on how the Islamic elements in this constitutional tradition limit or relate to democracy. And then finally, what I'm going to do is take a look and see what effect they have on human rights. So let me begin first. Can you build a constitutional democracy with respect for human rights on Islamic roots? My short answer is yes. The question is not whether you can in theory, but how it is done in practice. And let me, as I say, give a quick and superficial answer to that question. The alternative answer, that you cannot do so because you're mixing sources of sovereignty, is one that you do occasionally actually hear, but to me the surprising the surprising thing is how infrequently you hear that argument in Muslim political debates. You do hear it, but generally from the fringes. And I would say you hear it less over time rather than more. When a constitution was introduced into the Ottoman Empire, in Iran, you did hear the argument that there was something inappropriate about this exercise because fundamental laws should be expressions of divine wills, not of human authorship. And to this day, the Saudi Arabia has a basic law rather than a constitution. But outside of those and a few other examples, you hear, as I say, the argument far less frequently in political debates among Muslims than you might expect. The ways of combining these things are many. One, for instance, way of combining them that has been explored by both Sunni and Shia political theorists is to talk about the idea of trusteeship. That is to say, yes, ultimate sovereignty lies with God, but responsibility for human affairs was given by God to human beings, and that therefore a democratic system is one that is, or constitutional democracy, I should say, is one that is fully consistent with divine sovereignty. There's a more sort of practical way that you can do it that is of interest now, I think, to Islamic movements primarily. Well, I was going to say primarily in the Sunni world, but that's not quite true. That is, Islamist movements have discovered in recent years that they're pretty popular. And what they have therefore done as a result is often press for democratizing reforms out of the anticipation, perhaps self-interested, that they would do very well be able to win elections and increase the political and social space for their operation in that kind of environment. And so they've been particularly interested in looking at ways that they can combine their call for basing a political system on Islamic law, or the ways that they can do it by working through rather than around democratic institutions. They've begun to change their rhetoric a little bit. Muslim Brotherhood in Egypt, for instance, which for decades called for, the catchphrase was application of Sharia law, hasn't disavowed that idea, but increasingly talks instead about having a civil state with an Islamic reference. Exactly what that means, well, we'll have to wait till they win an election to find out. But what they're trying to signal is that they're perfectly comfortable working with the existing political institutions in the country, and what they want to do is breathe democratic life into them, convinced that should they do so, democratic majorities will pass laws with a strong Islamic coloration, drawing on the traditions and the values and the religious beliefs of the majority of Egyptians, so that they're, especially if your conception of democracy is narrowly political and procedural, increasingly friendly to democratic ideas. But what I want to do is to concentrate, not so much on the theoretical formulas. Again, in the discussion, we're welcome to bring me back to that if you like. What I just want to say, I want to deal very quickly with the argument that these are fundamentally incompatible. What I want to do now is to turn to that second task that I set for myself, that is to see how a specific constitutional tradition experiments with, in a sense, constitutionalizing Islam, an attempt to bring Islam into a constitutional order. And the experience that I'll look at is Egypt, where you see a very interesting pattern, and one that might be a little bit against what you would expect. You would expect that a constitutional tradition might be introduced very gradually, and one that would at first take on a very, very strong Islamic coloration, and then as it begins to operate over time, the Islamic element might drop out. In fact, it's the exact opposite. When the first Egyptian constitutional documents were written, they had no provision whatsoever for Islam. And there's been a steady inflation over the last 120 years in the Islamic and religious provisions. The first constitutional document for Egypt was written in 1881, and it was not called a constitution, it was called an organic law, but what it simply was a set of procedures by which the consultative assembly, an indirectly elected assembly in Egypt would operate, and the ways in which it would provide oversight of the government and legislate. It was just a narrow procedural document, and it had no explicit ideological content whatsoever, nationalist, religious, liberal, or anything. I mean, you can read some ideological content perhaps implicitly into it, but explicitly it made no provisions. And you wouldn't know from reading it whether this was a constitution for Egypt or Argentina. In 1923 Constitution, which was written by a committee of experts, there was some discussion of Islam in some provisions. Islam was going to be made the state religion, but when it came to questions of Islamic law, these were dealt with actually very, very quickly and very, very easily by the committee. The minutes of the drafting committee have survived, and we can see that although there were representatives from Egypt's various religious communities and some religious authorities on the committee, it was not a contentious issue. After this, other Arab states began to experiment a little bit more with more demanding language. The Syrian constitution proclaimed Islamic law to be a source of law. The Kuwaiti constitution did the same. So by 1971, when the Egyptians are writing, there are a couple interim constitutions that kind of follow the 23 constitution in making some vague provision for Islam, not for Islamic law, but for Islam. By 1971, when the Egyptians, however, are writing a constitution and what turns out to be the current document which governs the country, the debates elsewhere in the Arab world are beginning to have some impact on Egypt, and they're aware that there are more demanding formulas. And there was considerable debate on how to make provisions for Islam in the Egyptian constitution in 1971. Again, the minutes of the drafting committee have survived, and we see little debate on declaring Islam the official religion, little debate on some other issues, but when it came to what became Article 2 of the Egyptian constitution, there was a very sharp debate in the committee, which took place primarily between advocates of those who wanted to constitutionalize Islamic law, give some provision for it on the one hand, and two groups of members on the others, advocates for women's rights and representatives of Egypt's Christian community. There was a sharp series of arguments between them. But this was, for the most part, a debate that was carried out within the committee. It spilled out into the public a little bit, but it was not a very heated debate, even when it spilled out into the public realm. The final wording made the principles of the Islamic Sharia a principal source of legislation, a wording that was, on the one hand, for the first time, implying that the Islamic Sharia had some kind of legal status and constitutional status within Egypt, but wording that was sufficiently vague that it wasn't clear that it changed anything in the Egyptian legal or political order. In 1980, however, the Constitution was amended in a series of ways, but with regard to this provision, a simple addition was made of a definite article, so that before 1980, it had read the principles of the Islamic Sharia shall be a principal source of legislation. After 1980, the principles of the Islamic Sharia are the principal source of legislation. Again, nobody was quite sure exactly what that meant and what this change would mean. And I'll get back to sort of what they mean and how they've been interpreted in the Egyptian context. But again, the interesting thing that I want to note for present purposes is this process of what might be called religious inflation in constitutional discourse, by which matters become more controversial rather than less. And in fact, I would say that this sort of constitutional language is in one sense reflecting an increased concern with the relationship between the constitutional order, the legal order, and Islamic law. It reflects that, but it also causes some debate. Yesterday, I was just reading a newspaper account of a debate in the Egyptian parliament between members of the governing party and members of the Muslim Brotherhood, who are very healthily represented in the Egyptian parliament, and in which a member of the governing party said one of the Muslim Brotherhood's traditional slogans, "Islam is the solution," is a religious slogan and doesn't belong in the political realm. And so a member of the Muslim Brotherhood stood up and said, "Okay, well, forget that slogan. We'll just say Article 2 of the Egyptian Constitution is the solution." Got the desired headlines for this. So it's increasingly entered the realm of what might almost be considered bumper sticker politics, where people are hurling slogans at each other, and certainly a topic of hot public debate. Now let me broaden things a little bit and look not simply at the Egyptian tradition, but more broadly. How is it that my knowledge here is largely restricted to the Arab world? I'm kind of vaguely aware of what's happening in non-Arab states, but so the generalizations that I make right now are not about all Islamic states, but a minority of them that are Arab. What are the provisions that they make, and what effect do they have? The first is that they establish Islam as the official religion, and this is nearly universal in the Arab world. The only state that I can think of that does not make Islam the official religion is Lebanon. But what does this mean? What does an official religion? What does having an official religion mean? It probably means that arguments for strict separation of religion and state won't get you anywhere. But that's about it. States don't pray. They don't fast during Ramadan. So what does it mean to say that the official religion is Islam? It has little obvious legal effect, although it has tremendous emotional impact. Second provision that is fairly common but a little bit less universal is to require that the head of state be a Muslim. Again, it's a provision that is sometimes a topic of public debate. It was, for instance, in Syria in the 1960s. But the precise effect of this isn't quite clear. The practical effect is what I mean. I mean, the legal effect is very clear. If you're not a Muslim, you can't be head of state. But if you're dealing with a monarchy, well, all the monarchs in the region come from are Muslim, and there's little prospect of a Christian monarch. And if you're talking about popularly elected ones, there's very little prospect, I think, in a democratic system of a non-Muslim being elected head of state. So in a sense, it's requiring the people, if you had a perfectly operating democratic system, to make the choice that they probably would anyway. It's not clear that it changes the identity of any head of state. It's a topic of that if in countries that have significant non-Muslim minorities is a subject of some bitterness. But as I say, it's not clear that beyond the symbolic level it has any institutional effect. The third place where Islam often appears is in matters of personal status. And this is a category of law governing marriage, divorce, inheritance. And in many Arab constitutions, there are provisions that that matters of personal status will be resolved by religious law. Now, that doesn't mean that it will be resolved by Islamic law unless you're Muslim. So what it means is that each religious community has autonomy to have its have these cases decided in accordance with its own religious law. The interesting thing here is, again, the constitutional provision, I think, has very little effect. And the reason that I say that is not because personal status law doesn't matter. It does. If you look at the categories of law that govern people's lives, which people run into most, everybody runs into personal status law. But it's not clear that the constitutional provision has any effect because it doesn't answer the fundamental questions. There's basically, in the Arab world, no movement that I'm aware of anywhere that is seriously pushing for elimination of personal status law being on a religious basis and an institution of something like civil marriage. No Arab country that I'm aware of is there any serious move in that direction. So even if you didn't have the provision, any democratically elected political system is not going to move towards away from religious towards civil marriage. The really important questions, therefore, are who determines what the content of this law is and who's applying it. And there you have a whole range of institutions that give voice to this. For instance, in Kuwait, the personal status law for Sunnis is legislated by the parliament. If you're Shia, it is not. So what that means is that if you are if you are a Sunni, you go to a judge who may have no training in the sort of sources and interpretative techniques of Islamic law, but will simply pull out the code and apply it. If you're Shia, the same thing will happen, and you'll likely go before a Sunni judge, even if you're Sunni. In other countries, you will have courts that are not essentially run by the state, but more run by the religious communities adjudicating these kinds of cases. And and sometimes the law that they will apply will not be codified, so they'll be operating out of their own essentially traditional legal training. So some of the really important questions are: what court system has jurisdiction? Is the law codified? Who's got the authority to interpret what law is being applied and what isn't? There was, during the writing of the Iraqi Constitution, a tremendous debate about provisions for personal status law, and the debate was understood in much outside of the country as a debate between those people who favored an Islamic system and those who did not. But in fact, nobody was calling for a non-Islamic system. The question was just which courts are going to apply it. What happens if you have a mixed marriage, Sunni and Shia? Then which courts? Who's got authority? Iraq in 1959 had passed a uniform code of personal status that was supposed to apply to both Sunnis and Shia. And it was a matter of some concern by some Shia political movements who really wanted to repeal that law. But none of this really had that much to do with the constitutional text itself. The constitutional text itself, the debate over the constitutional text, and the final wording was such that it would, I'm not going to say it has no impact on the really important questions. It does have some. But most of the critical matters are left to regular legislation. That is to say, this constitutional debate over making personal status law on the basis of religion doesn't really answer the questions that people really need answered about who's interpreting religious law, who's applying it. So Islam turns up in those areas. Finally, it turns up sometimes in the matter of law. And here I want to return back to the Egyptian history that I was talking about earlier. There are some provisions in some Arab constitutional constitutional text that allow for or provide for the Islamic Sharia as being a source, the source of law. What do these phrases mean? And here what I want to do is to take a look at, again, the case that I know best in Egypt, primarily because that's where That's where the jurisprudence is probably most built up on this. And what I want to do is focus my remarks here to some degree on the effect that this has on democratic institutions, or at least theoretically democratic institutions. That is to say, how much does this provision limit the ability of Egypt's political authorities to make what law they want? Does it make it impossible, for instance, for the parliament to pass certain laws? Does it make it impossible for ministers to issue certain decrees? Well, my answer is that it restricts them less than you think it would. It's an odd text because it appears at first glance to be simply a declaration of fact. The principles of the Islamic Sharia shall be the principal source, or are the principal source of legislation. So it's just, I translated it as shall be, but it actually is probably better translated as they are the principal source of legislation. Okay, so what does that mean? That they actually are? That whoever wrote these laws used the Islamic Sharia? Or is it kind of an injunction to write laws, meaning that when you write a law, your first book you should go to is a book on Sharia? Well, if it means that, it's kind of difficult to enforce because you're basically telling legislators what to think as they're writing laws. So it's not clear that it means that either. It also talks about principles of the Islamic Sharia. Well, what are the principles? This is a legal tradition that is over 1,000 years old and that doesn't present itself as a set either of absolutely binding laws or of general principles. The practical effect of basically what happened was that the constitutional language was passed at the same time as Egypt was given, partly by mistake, a fairly independent constitutional court. So that I can tell you how this court got created as best I can if you're interested. But in the 1980s and 1990s, and up until the last couple of years, a very independently minded constitutional court emerged in Egypt that struck out in all kinds of interesting directions, taking essentially the human rights provisions of the Egyptian constitution, which are written in equally vague language, and trying to give them some teeth. What did they do when they came to this text? Well, the first case that they dealt with was one in which they dodged. They dodged because it involved a challenge to a law that predated the amendment of the constitutional text. So what they said was, okay, this law has no this constitutional provision does not apply retroactively. In other words, if a law violates the Islamic Sharia, but it was passed prior to 1980, then it's up to the legislature to change it. The reasoning was a little bit obscure, but that's what they said. All right, so that just basically signaled to people that what we've got to do if we want to give this amendment some teeth is find a law that was passed after 1980. And in fact, a very vigorous tradition or very vigorous practice of ferreting out possible cases by Islamically inclined legal and political activists began. And they began to try and find ways of challenging all parts of Egyptian legislation on the basis of Article 2, laws that had been passed after 1980, to the extent that, according to one estimate, about half of the cases before the Constitutional Court today relate to Article 2. The court sort of worked out an approach that basically said that a law would be unconstitutional in one of two cases. One would be that if it violated a Sharia-based rule that was absolutely clear as to its authenticity and meaning. That is to say, it was something that was unambiguously part of the Islamic legal tradition. And second, its application was absolutely clear. But that's when you're dealing with a legal tradition, again, that does not present itself in terms of codified law, but instead a 1,000-year-old tradition, that is really, in a sense, a set of interpretive techniques of canonical texts, that's very, very little. But the second thing that they said was that it had to be, Egyptian law had to be consistent with the goals of the Sharia. But the goals of the Sharia, which is something that is a phrase, principles of the Sharia is a phrase that no traditional Islamic legal authority would recognize, but goals of the Sharia is. And, but they're very, very vague. They protect things like, life and property and honor. But they're very, very general. And essentially what the judges of the court were saying, their position is coherent and defensible, but what it does is it shifts the burden to the political authorities, for the most part, to determine how Article 2 is going to be implemented. That is to say, it doesn't really place that much limits on the executive and the legislature. Because what it tells them, essentially, is that if you can come up with a plausible justification for this in terms of the goals of the Sharia, then the law is probably constitutional. Unless you violate one of these very few laws, or rules that are authentic with regard to their, or are unambiguously authentic and unambiguous in their interpretation, unless you violate one of those, you're probably free to do as you like. So that's the consensus that's the approach of the Constitutional Court. Now, the interesting thing is that it's one which is, despite the very noisy and sometimes nasty debate over the place of Islam and religious values in Egyptian public life, it's one which seems to be the subject of emerging consensus, even among people who are very sharply opposed to each other. The governing National Democratic Party really is able to talk about this Article 2 as demonstrating that it is fully in keeping with Egypt's Islamic culture, and it uses religious symbolism extremely heavily. And the Muslim Brotherhood says point blank, or at least some of its leaders have said point blank, we're happy with this approach. The Supreme Constitutional Court is legitimately interpreting Islamic law and applying it, and they are, at least one prominent leader of the Muslim Brotherhood has said that it is an appropriate institution to be applying Article 2. Okay, so in terms of the limitations that this places on democratic institutions, it's actually much less than you might think. There are limitations to the operation of Egyptian democracy that are extensive and intensive, but they don't stem from Article 2. They stem from other sources. If Egypt is not a democracy, and it is not a democracy, but the explanation does not lie in this text. What about human rights? I've talked about democracy. What about human rights? What does this sort of steady inflation in Islamic constitutional thinking have on human rights? Well, you might get the impression from what I've said about democracy that the Islamic political tradition is almost infinitely plastic. You can justify almost anything. And I don't think that's quite true. When you come to human rights, it is possible to ground some human rights in an Islamic legal and constitutional tradition, and in fact, groups have done so. But the pattern of where it's easy to and where it's harder to there's sort of an uneven pattern. And what I do here is try to look not at Islam, but at specifically Islamist political movements. What I want to do is to sort of answer this question is to take a look at Islamist political movements and see where they have been successful, or I shouldn't put it that way, where they have attempted to ground human rights in an Islamic constitutional or legal idiom, and where they haven't. And here the interesting thing is that Islamist political movements, and I'm talking here sort of mainstream movements, not sort of the fringe groups that are advocating overthrow of the political systems, but sort of the mainstream ones that are often, sometimes legal, sometimes not, but generally attempting to move societies by evolution rather than by revolution. The interesting thing here is that many of them have actually been in the forefront of calling for democratizing reform and specifically for political rights. When it comes to restrictions on freedom of the press, freedom of speech, and so on, Islamic movements, especially Muslim Brotherhood movements, have, and this is not just recent, but for quite some time, placed it actually high on their agenda. But what I mean here is a fairly narrow conception of political rights. I was reading a couple months ago a booklet of the Islamic Constitutional Movement in Kuwait, which is a Muslim Brotherhood movement. They're legal, they're represented in parliament, and they were putting together a booklet on what they were founded in 1991, and this booklet came out in 2006, so it was what have we accomplished in 15 years of political activity? And they had in this booklet, one of their accomplishments was some amendments to the press law. And here's what the booklet said. It claimed to have made a great breakthrough for press freedom in Kuwait by diminishing the licensing requirements for publishing new newspapers. And in fact, it became much easier to publish newspapers in Kuwait. And also imposing criminal penalties for those who abuse this freedom by publishing things that were insulting to Kuwaiti values or Islam or religion. At the same time, they were liberalizing and deliberalizing. In the same sentence, they were bragging about both. What's going on here? Well, what I think this illustrates, in a sense, and I'm going to be sort of quick and superficial here, is that it's far easier to ground claims for narrow political rights in at least the Islamic political tradition as it's interpreted by current Islamist movements, and far more difficult to ground cultural and social freedoms. Religious freedom, for instance, meaning the freedom to practice religion within your own religious community, is very easy to ground in Islamic tradition. Total free thinking, that is, operating outside of any established religious tradition, is extremely difficult. So it's an extremely uneven pattern. Now, exactly how this works out in practice is not quite clear, because the Islamic movements that I'm talking about are ones that do not govern. But in fact, the pattern of their own rhetoric, and these are movements that pride themselves on their ability to sort of keep a close pulse on public opinion. So the pattern of their rhetoric suggests that they are convinced that this kind of approach resonates with broader publics. So my hunch is that any move in a democratic direction would probably empower those who had this kind of conception of where human rights could be very well grounded within an Islamic tradition and where they couldn't. Okay, let me now return, sort of to wrap up, to the task I set myself at the beginning. First, can you build a constitutional democracy on an Islamic foundation? And the answer that I gave was essentially, yes, you can in theory, but the question is how you do so in practice. The second question I asked is how Islam actually appears in constitutional texts. I showed how this inflation took place, particularly in Egypt. Then I looked at what the effects of this are in practice, focusing on an emerging position that seeks to use Islam to limit what laws can be passed, but in a way that, as I say, generally works through rather than around existing political authorities. And then I looked at the effects of trying to ground human rights in an Islamic legal tradition, showing how some rights, especially political rights, are easier to ground than other rights, especially the social and cultural ones. And I should add, collective rights are often easier than individual rights. So I said at the beginning that it's customary to begin a presentation in an academic setting with a joke, And perhaps my whole presentation is that joke, because what I've succeeded in doing is just making the waters far muddier. But what I have tried to do is to show how in the Arab world there's been intellectual attempts to explore how these various elements, Islam, human rights, constitutionalism, democracy, can work together. Those intellectual explorations have led in some very interesting directions. But what many of these debates boil down to is really, in some cases, debates not simply over whether Islam should play a role in the political order, but who has the authority to interpret and apply Islamic legal principles. And when it's seen that way, in a sense, this is a debate, as I say, sort of often the what is much less important than the who. And the interesting thing is that although that's, I think, the case in practice, because much of this debate has taken place on a theoretical level, the debate appears to be over the what. And as a result, the people who are advocating for an increased role for Islam in the political order have paid far less attention to the who. I think if they ever made progress in pushing the Islamicization of the political order further, they would be pressed to answer these questions of who has authority. And the interesting thing here is that any attempts to answer this question probably would have to take constitutional forms. That is to say, a constitutional text would be the good place to begin to sort out who's got ultimate authority for determining what interpretation of the Islamic legal tradition is to be applied. And so, in a sense, any progress that they're going to make is going to require further constitutionalization of Islam rather than undermining any constitutional tradition. Thank you. I'm happy to entertain any questions. And if I remember, the tradition is students ask first. So is this to give students to write or to give them a strong shove? Yeah.
I think what you presented made a lot of sense, but can you please expand a little bit further on whether the constitution in Egypt has the strength and potential to protect legislations from Islamic rule if the Muslim Brotherhood, for example, gets to the power, or I don't know, or if the Muslim Brotherhood gets to the power, they can use any kind of flexible justification about Islam and be able to control the legislation completely. What I want to refer to is mainly Turkey and also Iran. I think something similar is happening in Turkey right now, that after a little bit more fundamentalist Muslims have been able to get a hold of the power, there is a lot of concern among the seculars about whether the constitution can prevent them from using Islam as a very flexible justification. And also in Iran, I think 29 years ago when the revolution happened, I think the revolutionary forces got the power after a referendum. They got the power after quite democratic process, but after they got the power, they were able to use the constitutional Islam to get rid of everything else.
Yeah. Okay. So yeah, the question is whether the Egyptian constitution has sufficient strength to be able to place real limits on the Muslim Brotherhood if it came to power. And my answer would be probably not because of, but not because of its Islamic provisions. Essentially, the Egyptian constitutional system sets up a system in which authority is basically concentrated in the executive, and there aren't real checks on executive authority. So it winds up being a circular system. If it had robust institutions that were able to hold the executive accountable to clear constitutional legal standards, then it would act in that manner. But in essence, it doesn't do so. It doesn't place any real limits on the current government. I'm not sure it would do any different on the Muslim Brotherhood. The interesting thing here is that the kinds of reforms that Egyptian political reformers, both in the Brotherhood and more liberal reformers, are calling for would be a change in the Egyptian constitutional tradition, essentially to give much more authority to the parliament and to give the a judiciary, which has some autonomy, to increase its autonomy. And the Muslim Brotherhood very much endorses those efforts, perhaps anticipating that they would give the Muslim Brotherhood much more political space. But the effect, I think, would be to move Egypt towards perhaps something more closely approaching a parliamentary tradition, and if you design it in the right way, one that would force the Muslim Brotherhood, which, I mean, its own leaders, if you ask them, if there were a totally free election, what percentage of the vote would you get? They say about half. So there are certainly constitutional mechanisms you can design that would force them to, even if they came to power, to do so only in coalition form. So again, it's not so much because of the platform of the Muslim Brotherhood or because of the Islamic provisions of the Egyptian constitution that would block any attempt to hold the Muslim Brotherhood to power. It's the existing constitutional structure right now, which Egyptian political reformers, I think, are trying very much to change. I'm not sure they're going to be successful. There's talk of constitutional reform in Egypt that is probably going to, if anything, have the opposite effect. But that's where the reform efforts are going. Yeah.
You mentioned in your talk about Egypt promulgating, or the definite article being used as constitutional law shall remain, or the source for it shall be the Islamic law. And I was wondering what you thought, what might be a way to reconcile the different schools of thought that exist in the Islamic world as to the different law schools and how their different takes on personal status laws might be reconciled together under one constitution.
Yeah, the question is how you could reconcile different legal schools in one constitution, or sort of applying this constitutional text. And my short answer is, in a sense, that's what the court is trying to do. It's saying if there's anything where legal authorities in all schools of law agree on, then that's a clear, unambiguous Sharia ruling, and legislation cannot violate that. But that's going to be very, very small. And a cynical way of handling that is to say, wait, any time that there's significant dissent within any school of law about any question, then the government can do what it wants. And I'm not sure that cynical approach or cynical criticism is unfounded. I think it might be fair. So the question probably comes up to some degree less in Egypt, where there's much less plurality of this, and much more in countries that have different legal traditions coexisting, like Iraq, where you've got sort of the Sunni Shia mix, and they're completely different. I mean, in Egypt, you've got much more of a unified tradition of Islamic legal thought, and even a unified set of texts that they're dealing with. When you're talking with Sunni and Shia, the Quran is the same, but the body of hadith literature, basically the practice of the Prophet and the early community, are different. So in a case like that, reference to Islamic law is going to have much less, it's just going to determine an awful lot less. And leave democratic, or I should strike the word democratic, but leave just regular political authorities much more room to maneuver. So I don't think you can easily do that. And just one other thing. I mean, I would say that even if you do that, most legal authorities, especially within the Sunni tradition, the Shi'i tradition gets a little bit more complicated, would say that essentially nobody has the right to determine any kind of Islamic law or any interpretation of Islamic law authoritative. They can have it binding. In other words, the ruler has to make a decision what interpretation we're going to go with. But that is, in a sense, legally binding for as long as the legitimate political authorities enforce it. But it's not doctrinally or binding. In other words, nobody outside of the ruler who decrees it, this will be the interpretation applied, nobody has to believe it or accept it as, they just have to accept that this is actual practice, not that it's the best interpretation, so that it can easily change when the political authorities change, or when the political authority changes, when the political authorities change their mind. Questions? Yeah.
When you say states don't pray, what do you mean by that? Because when politicians are inaugurated, when parliaments open session, when holidays are declared, when government offices close, aren't those all the establishment of a church? Isn't that in effect the state praying, what we say on our currency, what we say when we salute the flag, you know, all this kind of stuff? Aren't states praying in that sense?
Question is, yeah, aren't states praying when they declare holidays and so on? In a sense, prayer is not necessarily the word that I would use for that, but what I would say is that every single example that you cited was one that comes from American practice, where we have no official religion. So in a sense, the point that I'm trying to make, even if I'm completely wrong in my reasoning, the conclusion I come to is that it has very little legal effect. Still holds. In essence, you take away the text making Islam the state religion, I'm not sure you change anything, except how people feel. But you don't necessarily change anything institutionally or structurally. Yeah.
At the beginning of your talk, you said you were going to problematize democracy, human rights, constitutionalism. I'm wondering if what you haven't done at the same time is problematize what's on the other side of it, and that is Islam. I mean, what comes through this is that in many ways there is, especially with the emphasis on authority, there is a great debate over what it means, what Islam means, and it's frequently, especially in this context, equated with Sharia or with Islamic law. But many people say that Sharia hasn't been in practice, and I'm talking about both academic critics from outside and also in the community, hasn't been in practice ever since the beginning of the codification of Islamic law. So can the criticism actually be made that we don't really have an Islam to talk about? If anything, we have multiple Islams, and that the question itself may require a reconfiguration.
Yeah. Trying to summarize the questions, and that's a fantastic question, but almost difficult to summarize. But is there any Islamic law that can be easily applied, implemented? In a sense, I mean, I'm going to completely rephrase your question. If there's an attempt to implement the Sharia, is there any Sharia that people can agree on to implement? And the answer, I think, is partly no. That I think very few, I shouldn't say, well, yeah, I would say very few Muslims within the societies that I'm talking about would question whether or not the Sharia is proper practice. But what it is, how you derive what it is. I mean, Sharia is the right way of doing things, the Islamic way of doing things, and that's obviously something that people can argue about. But what has happened over the last couple hundred years is that the structures and the interpretive techniques that have been used, some of them have decayed. Structures and interpretive techniques to determine the Sharia. Some of them have decayed. Some of them have been joined. There's now this great cacophony of voices about what correct Islamic practice is. So how can you take this cacophony and turn it into a political system? And there are two possible answers to this, and I'll give you both answers that are diametrically opposed, and then tell you which one I believe. The first answer is just to say Islamic legal tradition is dead. And there's authorities who say that. It says basically it died maybe 200 years ago, didn't die 1,000 years ago, but 100 years ago. And in essence, when people talk about Islamic law today, they're talking about something that is completely different from anything that somebody trained in the traditional sciences of determining and interpreting Islamic law, they just wouldn't recognize either the techniques or the conclusions that people come to. And the attempt to codify, to write it down, to teach it in law schools, all this is so completely alien to the Islamic legal tradition that it's become something completely different. And the other answer says, yes, that's true. And so what we see is, in a sense, a transformation of Islamic law. And what we see in cases like the Egyptian Constitutional Court is an attempt to invent a new Islamic legal tradition with a new set of institutions and a new set of interpretive techniques that will be authoritative, but that is appropriate to the kinds of political structures that exist in the world today. And when I first heard that second argument, I was sort of skeptical. I'm becoming more and more convinced that essentially that is what is increasingly happening, simply because of how seriously people take this, and it is beginning to have institutional effects. So it is certainly true that Islamic law has transformed in ways that some people are only slowly coming to grips with, or sometimes people obscure. When you call for application of Sharia, you're masking the transformations that have taken place in authority and techniques and in content and so on. But it still does mean something. When people call for application of Sharia law, they sometimes have very specific changes that they want to see. And for that reason, it's not just a vacuous answer to call for Sharia. It has changed, but there's still something to it. Yeah.
Thank you very much for speaking tonight. Wow, this afternoon. I feel like there's a lot of interest in this issue of Islam being compatible with a Western idea of constitutional democracy because of the wars that the West is involved in right now in Iraq and Afghanistan, and we're starting to talk about that a lot more. I wonder what and your examples of sort of constitutional democracy and Islam working together were from, Egypt and Kuwait, which I know is your specialty. Can you give some examples of how the present situation and the present conflicts are maybe changing the perspective of how Islam and constitutional democracy could work together?
Changing perceptions where?
Maybe they aren't changing.
I'm sorry?
How it can work, the model of combining constitutional democracy and Islam can work when there's such opposing sides between the West and some Islamic supporters in Iraq or Afghanistan.
Okay, yeah, so the question is wait, how sort of recent events and recent conflicts have affected the attempt to bring Islam and constitutionalism together? Okay, I mean, a good question, but sort of general one and hard to answer. I mean, what I would say is that most of the interesting debates that are taking place domestically within these societies. And of course, they're affected by war in Iraq, war in Afghanistan to some extent. But they're really, these arguments are older than that, and they really kind of go to the core of, who has political authority, how it should be exercised. That recent military conflicts don't really involve. What has happened essentially is that when the United States essentially decided to involve itself very, very heavily in matters of domestic governance in the Arab world, basically in 2002, 2003, 2004, it found itself running smack into the middle of these debates. That happened in Afghanistan, it happened in Iraq, and then sort of with the whole democratization push, it happened elsewhere as well. I'm not sure the American involvement has really changed the terms of the debate that much. It has had an interesting effect in the United States, I think. In one sense, I mean, what I'm saying here, I might have trouble convincing people of, but I think it's led, if I go back to the way the debate was framed in this country, 2002, 2003, there was an extreme allergy, I think, to anything involving Islam. And actually, I think that's decreased. I think most people would disagree with him, but I think that's actually decreased. And there's an increasing sophistication that may have come 2 or 3 years too late about the complexity of these questions. and about the nature of these debates. When I talk to people in Washington who have not necessarily any background or interest, but who are, because of the press of recent events, increasingly paying attention to these kinds of debates, I find it not simply a greater level of interest, but a greater level of knowledge. As I say, it may come 2 or 3 years too late. But I don't see the same kind of allergies towards talking about these kinds of ideas, especially the farther you get away from the core conflicts in, say, the Israeli-Palestinian or in Iraq. When I look at Morocco, for instance, many Moroccans are convinced today that the United States wants the Islamist party to come to power simply because the United States is not treating the Islamist party there as a pariah. In Iraq, we're working very closely with Islamic political parties. There's a debate right now about exactly, well, what to do with the Muslim Brotherhood in Egypt. I mean, there's pretty much a hands-off attitude towards them there, but at least there's some debate about exactly what the American attitude should be. So I think it's as I say, increase the sophistication. Whether it changes policy or not, I don't know. Yeah.
So, Islam and constitutional democracy, I mean, we consider them like oranges and apples, and can we make a fruit cocktail with these two? That's the question, apparently. My question is, when we're making laws according to Islam, or in these countries that you have mentioned, Egypt and Kuwait, is commitment to Islamic lawmaking sincere, or is authorities exploiting Islam in a way to, when they are lawmaking, to strengthen their authoritarian stand in the countries? So is the sincere commitment to Islam, or is Islam exploited in a way to serve to these people's authoritarian grasp?
Yeah, the question is the Islamization that takes place in constitutions and laws simply being exploited for authoritarian purposes? The answer, of course, is yes. The constitutional text that I talked about in Egypt, why was it amended in 1980? It was essentially to reorient the legitimation of the Egyptian regime in sort of a more conservative, more Islamic direction. That was what was going on. It wasn't about really changing the Egyptian legal order, but simply presenting the Egyptian political order to the Egyptian population in a slightly different way, sort of reframing where they said they got their authority from. And it was done at a time when with some other political reforms were brought in that I think, again, sort of reconfigured but didn't fundamentally alter the nature of Egyptian authoritarianism. So yeah, that is what's going on. I would still say that what's going on in the hearts of the people who are writing these laws does matter, but sometimes they have institutional effects, and that's essentially what happened in Egypt in the 1980s and 1990s. They didn't anticipate how much this would have. I mean, politicians have all kinds of reasons for doing what they do, but I wouldn't necessarily dismiss the effects simply because they're doing it in order to augment their authority or essentially pander. None of the effects that I'm talking about, I think, really were themselves designed to bring about interpretations of Islamic law that were in themselves authoritarian. That is to say, what they were designed to do was to increase the ideological appeal of the existing regime. But they weren't necessarily designed to allow it to operate institutionally in a more authoritarian manner. If anything, they had the opposite effect. Not much of one, but they had a slight opposite effect. But if you're talking about what was in their hearts and in their minds, yes, you're absolutely right. Okay. Yeah, one more question? Go ahead.
I'm wondering if you could speak just a little bit about the implications of Islamic constitutionalism in mixed Sunni-Shia communities, reflecting on your reading of the Iraqi constitution, and how in Iraq or in other places that have perhaps less developed constitutions like Bahrain or Kuwait, where there are large communities of Shia, how does that impact the way that you integrate Islamic law or references to Islamic law in your constitution? And what does that imply for who interprets that in those kinds of states?
Yeah, the question is what happens, or how does the existence of a sectarian divide, Sunni-Shia, in a society affect the constitutional language and the institutional patterns? And the answer, I think, partly is that nobody knows quite yet, because the Iraqi constitution, I mean, it certainly affected the way that the text was written, but in ways that I wouldn't, in ways that were kind of unique to Iraq. Bahrain, to some extent, I would say the same thing. It affects it partly in the sense that when people vote, as they do in Iraq and Bahrain, primarily along sectarian lines, a lot of the Sunni-Shia debate is really a debate about, for instance, if you're going to have a parliament, which is a majoritarian institution, right? How much power is a parliament going to have? This has nothing to do with different interpretations of Sunni versus Shia interpretations of Islamic law, and more who can turn out their supporters at the polls, and what kind of reflection. It does sometimes, however, affect. It does sometimes go into not simply parliamentary versus presidential system, electoral system, and so on, but concrete structures. But the problem is that there's very little experience with really trying to design structures that address this. For instance, in Iraq, when they got to the matter of the Supreme Court, there was some sense on the part, especially of Shia drafters, wait a second, this is the Supreme Court is going to have jurisdiction over constitutional disputes. The Constitution makes some provision for Islamic law. Therefore, we need some Islamic religious authorities on that court. Well, who's going to select these authorities? Who are they going to be? Are you going to have Sunni, Shia? Are you going to have some kind of mix? These were questions that they could not answer. And so they basically just said, okay, we'll pass a law that answers all these questions. And I would say it will be tremendously complicated when they actually pass the law for all kinds of reasons. First, there will be the Sunni-Shia split. There will be the Arab-Kurdish split. And there's also the fact that although the Shia want religious authorities on that court, most senior religious authorities would probably have nothing to do with the court of that, considering beneath their dignity. So where are you going to find people to sit on this court? It's just not quite clear exactly how that's going to operate. So I would say, basically, in answer to your question, people have only begun to grapple with what that means in terms of applying religious law in a society that really legitimately accepts a multiplicity of sectarian interpretations.
Okay, thank you all for coming. Thank you for busing your lunch and paraphernalia on the way out, and thanks especially to Nathan Brown. You might shut it down, or is that? Okay, all right. No, we have a body mic too. I forget where it's.
Yeah.